Hi guys, it's Kathy. I hope you're doing well. So, the 19th, it is Tuesday. We got a lot of Judge Ponder today, and I'm excited. We have a new judge, and I'm excited. They're both from Colorado. Oh, wait a second. You know what else I have that I could play a little bit of? Yes, I think. I have.
I'd ask, do you think
Yep,
you
I do
understand
have
that
it.
part 2 information?
I have North Dakota. No, South Dakota. I have Minnehaha. And I can't remember if it's North or South Dakota. But I do know that I have some vibers from South Dakota, I think, that chat, that comment all the time. So I just got to grab that. All right. All right. Let's start, though, in Colorado. It's East Dakota. There we go. All of us, or Megaha. Ah, ha, ha, ha. Minnehaha. They the judge still calls it Minnehaha, which is not what they said that it's called. And they're from Dakota. They said it was called Minnehaha. Anyway, this is Colorado.
24 CR 4087 set for sentencing today, and then a traffic and misdemeanor case that are both set to be dismissed pursuant to the agreement in the felony matter. This is an open sentence with a cap of 8 years in the Department of Corrections. We have an acceptance to CAE and a recommendation in the PSIR for CAE. Everybody on the same page so far?
Yes.
Okay. All right. People, sentencing argument.
People are respectfully requesting 4 years, the lowest end of the DF2 presumptive range at Department of Corrections. This is a case as a whole where Mr. Meisner was originally charged with a DF1. That's a result of possessing DF4 amounts of fentanyl. The mitigation that really stood out to me in this case, and it's almost like a defense advocacy here, but it plays a part into my request, is that Ms. Meisner is a victim of another case in another county. That case is, I wrote it down. I didn't write it down, but nonetheless, Ms. Meisner was a listed victim in a case in another county where she was kidnapped, and who knows what else besides Ms. Meisner. Ms. Meisner informed the PSIR writer as well as the officers that her possession of that firearm was strictly for self-defense purposes. And looking to the purpose of the special offender statute is to allow greater penalties for drug traffickers. I think Ms. Meisner is a drug addict. That the fentanyl in her possession on that day was for personal use, but by law, had we gone to trial, I'm confident that we would have been successful on the DF1 conviction. Ms. Meisner is receiving great benefit here with a 4 to 8 DF2 offer, it being open to the court and in your discretion, taking all things into consideration. But the things I'm asking the court to take into consideration is that a comp court sentence would unduly depreciate the seriousness of the conviction itself. This is a DF2 for possession with intent. This does come after a very likely success of a DF1 at trial. That with Ms. Meisner's benefit, sorry, let me restate that. That the purpose of sentencing is to punish, that the punishment is fair and consistent, and that the defendant's individual characteristics, in this case, Ms. Meisner's characteristics need is for structure, as written by the PSIR writer, and it is to reduce the ability of Ms. Meisner to reoffend. So for all these reasons, Your Honor, the people are asking for the lowest end, 4 years at the Department of Corrections. We are not reserving restitution in this case.
All right, thank you. Then pursuant to the Weeks case, I will make a finding that there is no restitution. Ms. Martin.
Judge, defense is requesting a 2-year supervised probation sentence in this case. I think all of the
Thank you, Kelly.
terms
Thank you.
laid out
Thank
in
you.
the PSI are appropriate here. Ms. Meisner does not have any criminal history prior to this case. And the only other conviction it looks like is a petty offense for an underage case. Other than that, I don't see anything. I think that's indicative that she could be successful on probation. I think the prosecutor already pointed this out, but the reason for the firearm here was the self-defense based on the 24 CR 5121 case. It was for protection. I always think there's an interesting equal protection issue in DF1 cases where there's another purpose for the firearm, and or there's a pretty clear issue of personal use based on someone struggling with severe addiction issues. I understand the law is probably not on my
Kelly,
side on that.
thank you.
I do think it's something that is mitigating, and I think the prosecution agrees here. It does sound like there's some negotiations that happened where the prosecution didn't think that ComCore was inappropriate here. My understanding is the prosecutor's office policy on these types of cases is to always ask for prison sentences. So I don't think that individual prosecutors have much discretion in asking for different sentences other than Department of Correction sentences. But it does seem like there were negotiation conversations that happened where Mr. Donnelly might have been told otherwise. Ms. Meisner does seem like she is making good strides in her recovery progress. She is in a MAT program and she is doing this daily. So I think the court has seen a letter from her recovery coach. She is moving in the right direction there. She's extremely young, Judge. And I think the court obviously is familiar with CAE, and there's always some concern with sending someone of her age to CAE. I don't think anyone is ignorant here that there are not drugs in that facility, and putting someone in that environment who is at this stage in the recovery, I think can be frankly more harmful than helpful, especially if they are doing well in their
Monica,
recovery,
thank you.
making the progress they are making,
Hi, Kit Kat.
have
Hi.
a recovery coach already, are enrolled in a MAT program. They have things set up. Ms. Meisner also has a support system. The court can see she has family and friends here with her today. There's another letter, I believe, from a Jason Gibney, who has talked about kind of the internalization of the gravity of the situation since she's been charged with the crimes. I don't believe, I think someone maybe potentially wanted to read an additional letter. Did you want me to read it? Yeah. Okay. If I could have a second, Judge.
Yes.
I think she would like to read the Judge.
Morning.
Good morning. Do me a favor. Start by stating your name and spelling your last name for me.
Okay, my name is Kimberly Usler. My last name is Heusler.
Okay. Go ahead and come on up closer to the microphone. And what is your relationship to this case?
I'm a friend.
Okay.
I'm a friend of her girlfriend's mother. Is how I met her.
Fair enough. All right. Go ahead and tell me what you would like me to know, please.
Okay. I've had the privilege of knowing Scarlett for about 2 years now. And in that 2 years, I've seen her do leaps and bounds. I mean, for her age, she's responsible. She has good work ethics. I recently bought a home and she's helped me do all the renovating on it. So she's organized. She's been great with the materials. I moved my elderly parents in, which she's helped me with. And believe me, that's a job. And I don't want to discredit the crime that she was involved in, but I'd like to, I'm working at 12 steps with her currently. So I'm a little emotional.
You're okay.
But she okay. Her current legal situation, well, she is serious and it is rooted in deep in her, excuse me, is rooted deeply in her tragic backgrounds. Scarlett was heavily influenced by the people in her life on her drug use. This wasn't a choice that she made recklessly or in disregard for the law, Your Honor. This is something that a young woman raised in extreme or difficult situations had turned to. She's experienced homelessness, significant trauma, the kidnapping, and she understands that she has a very heightened sense of fear. And that's the reason why she found herself with that firearm. It was not it was in a desperate measure for protection, not for aggression, Your Honor. I've myself been to DOC. It was 25 years ago. And I would not recommend, because of being there, recommend that to someone of her age. I would ask that you give her a chance to prove herself. This is the first time she's ever had to be accountable. And I think a halfway house would be more than enough punishment for her, because that would give her the grounds of having to be accountable. And like her probation officer said, there's no drugs in there. There's drugs in prison all over the place. They build gangs. They sit there and talk about the crimes they committed, and it's just not a good place for somebody for their first time offense. I think she would get more out of going to community and being under that structure and being held accountable for everything that she does, instead of going in and listening to all the stuff that goes on in there. And chances are she could walk out of there a worse criminal than what she walked in as. And I was
Thank
very
you,
fortunate
Kelly.
I stayed out of that
Thank
record. But I was a little older, and but I seen a lot of girls in the 2 years that I was there come right back in because they tried a crime what one of their cellmates told them about, and it's crazy, Your Honor. And she's sincere about her sobriety, though it's a hard one because her drug of choice is pretty harsh. And but she's sincere about her sobriety, and she wants to be a good member of society. She wants to get where I'm at. And I think she could do that without going to prison. But if she messes up, then I think she should feel what it's like in there. But for her first time offense, Your Honor, I feel that would be appropriate for her. She's come a long way. And the last 60 days, we've been working the steps. And I've learned a lot about her. And she's come a long way. And I believe she'll be successful. I believe, she has what it takes to go out there and get herself a good job, maybe a little more education.
But she's so little. She's so young. I thought a 12-year-old boy was on trial here. That's what I thought. I thought when I first started watching it, it was a 12-year-old boy.
And do life by life's terms. Thank you for listening.
Thank you. Thank you for being here. Smart. I didn't know if you were still going, or if your client wants to address the court at all.
That was about, I think, all that I had for Mr. Donnelly's notes, Judge. The only thing that I would mention is just skimming the PSI. I think it is very indicative that she is taking accountability, a lot of pretty blunt statements about needing help, acknowledging where she is at, nothing trying to minimize her behavior. So I think all signs that she is willing to work and comply with whatever court orders.
Right, Ms. Meisner, is there anything you want to tell me before I impose sentence?
I would just like to say, I know what I had done, and I know that it was wrong, and I'm willing to take accountability for that. And I apologize for the people it may have hurt. And I apologize to myself, because now it's putting me in situations that I didn't have to go through if I just didn't do what I did. But I take accountability for everything that I have done, and I'm willing to make that change to better myself. Thank you.
All right, thank you. All right, well, this case is certainly not as heavy as the one I did earlier, but it's no less important, okay? All the same factors and considerations I need to consider as far as what the appropriate sentence is. First off, we'll handle the easy part. 24T6881 and 24M5970 were both dismissed pursuant to your plea agreement. I have said many times before, and I think just demonstrated with the previous sentencing, that I certainly weigh very heavily probation's recommendation. Probation does a very lengthy pre-sentence investigation report and makes recommendations on each case. I am still reeling, a bit shocked that I had a recommendation of probation on that last sentencing. I am not particularly surprised that there's a recommendation for community corrections in this case. It's a very serious crime, but as was just pointed out, it's your first felony, first adult felony at least. There was some juvie stuff. I don't remember if those were felonies or not, but your first adult felony. And if we can get you the help you need and get you out of the system, then that's the right sentence. If we are unsuccessful with that, then maybe I'm wrong and prison becomes the correct sentence. But there's a recommendation that you need the extra structure and that a CAE sentence would be appropriate. I think that's appropriate in this case as well. I was impressed with the letters. I don't often have kind of strong letters like that from the people that are working with you and actively treating you. And so I think that says something. I appreciate your statements, as were pointed out in the PSIR as well. That said, I guess it's easy to say the right thing now while you're standing in front of me facing sentencing. I still consider it, right? Because believe it or not, even though it's easy to say the right thing, a lot of people still don't say the right thing. So you get points for saying the right thing, but it's easy to say it now. It's harder to kind of walk that after you leave the courtroom. Make sure you do. You do not want to wind up in the Department of Corrections. You're not going to get the help you need there. You are essentially warehoused. And if it comes to that, it comes to that. But I don't want it to come to that. And I assure you, you don't want it to come to that. A couple of things, and I've already told you what the sentence is going to be, but it's worth mentioning, right? First off, that gun's not going to protect you from anything if you're passed out in the car. Right? And second, you don't have to worry about anybody else, because if you're using fentanyl, that is going to kill you. Okay. It is absolutely the most dangerous drug we're dealing with right now. And so, those two things, right? You don't have to worry about anybody else. If you're using fentanyl, you're going to take care of it yourself. And you're not able to use that gun or any weapon in defense if you're passed out in the car. So you really need to get the help you need. I think it is important, like the DA noted. It sounds like a very serious case that you're a victim of, right? You need to get the help for that too, not just the fentanyl treatment. If you need therapy or something like that, get it, okay? I can't imagine. That's something I can't relate to, right? I can't talk to that because I haven't experienced something like that. But you're going about it the wrong way. And I know that's easy for me to say, but that's the truth. I am going to impose a 4-year CAE sentence in this case. What I'm going to do is I'm going to have you report the CAE. I'm not going to take you in custody and have them pick you up. I'm going to have you report the CAE. They want you to report generally by noon. So I'm going to order that you report prior to noon tomorrow to CAE. If they don't have a bed available, they're going to tell you when to come back, and you have to come back every time until they have a bed. You need to be prepared. Hopefully they have a bed available tomorrow and they take you in right away. Okay. But you will report there or be in violation of the sentence prior to noon tomorrow, and then follow their directions from that point forward. Okay.
Okay, thank you, Ron.
It's going to give you structure. Your attorney's also right. There's going to be the opportunity to use at CAE. There would be the opportunity to use at the Department of Corrections. So nobody else can do this all for you. You got to do it yourself. It sounds like you're in the right place.
That's why I thought they would never give her CAE, because of all the drugs there. I thought they were going to put her on probation. Nope, they gave her 4 years.
Stay in the right place, okay? All right, good luck.
Thank you, Governor.
Thank you.
Now, let's go to Minnehaha. And it's this one right here. I didn't watch this yet. I just wanted to show Dakota they always start every comment with, I think it's capital S, lowercase o, capital D, okay. So I think, but it could be an N. I'm trying to remember.
I'd ask, do you think you understand that part 2 information and its possible impact in your case?
Yes.
Then I would enter a not guilty plea on his behalf to all charges and matters against him. By file number, his case would be assigned with Judge Sabers unless there's a reason for a different judge.
None that I'm aware of.
Thank you. James Sadkovich for the state, Your Honor. Ms. Beck, is Mr. Roby your client?
Yes.
Thank you.
Sort of a middle ground. So she's going to be locked up, but she gets to work through it. So at first she'll be straight locked up, and then she'll go through a bunch of drug programs and things like that. And if she completes those, and if she does well, then they'll give her a weekend or a night out. And then she comes back. And she stays locked up, and she gets drug tested as soon as she gets back. And then the goal is to get her a job. So they're going to keep drug testing her, keep working with her, keep sending her to classes as she's locked up until she can get a job. Once she gets a job, then she gets out every day for that job, and then she has to come back. Once she does well in that, saves up enough money, then she can get an apartment. But she has to live in, one of the houses with other people who are going through the program. It's definitely sober living, and they're not locked up in there, but they're supervised in there, and she continues to drug test and things like that for 4 years until she's released. And then hopefully by the time she's released, she's already working. She already has her own place because she moves out of that place eventually. They need the beds into her own place. So that's how it works. It sounds great. That's not a porch.
Do you want to address bond?
We would keep it, we would ask to reserve it at this time and keep it at the current post and adjust later.
Thank you. So bond will be written as reserved for purposes of this hearing, but I am signing the scheduling order for your case, Mr. Roby. You'll get your own copy of this document. Ms. Beck has your other copy. The state gets a copy and one's filed. When you read it, it might look like legalese, but what I try to tell everybody that has concerns about that is that mainly you'll just want to make sure you stay in touch with your attorney so she can defend you against these charges. And also so that you don't somehow end up with a bench warrant for losing contact with your attorney or a charge against you for failing to appear in court. And otherwise, I think you're done this morning, so I'll excuse you and wish you good luck in your case, sir.
Thank you.
Thank you.
Good morning. My first case is Janelle Olson.
Okay, thank you. Ms. Olson's file number is CRI 25-5618. Ms. Avis is here for the state and Ms. Hofer for the defense. Ma'am, are you in fact Janelle Ray Olson?
Yes, I am.
Now, when I first would ask you, ma'am, if you could hear and understand when I explained your rights earlier.
Yes.
Did you have any questions about that explanation of rights?
No.
When I look at your case, ma'am, there is an indictment and a Part 2 information. The indictment has 2 felony charges. It alleges that on or about July 15, 2025, that you engaged in conduct which led the state to charge you with count 1, unauthorized possession of a controlled substance listed on Schedule 2, namely methamphetamine, with the intent to manufacture, distribute, or dispense it. That is a Class 4 felony carrying a maximum sentence of up to 10 years in prison, $20,000 fine, and also has a mandatory minimum prison term of 1 year. Count 2 is a charge of unauthorized possession of a controlled substance listed on Schedule 2, namely methamphetamine. That's a Class 5 felony carrying a maximum sentence of up to 5 years in prison and a $10,000 fine. The other charges here are misdemeanor offenses. Do you think you understand these 2 felony charges and their maximum possible sentences so far, ma'am?
Yes, I do.
Now, there is a Part 2 information that alleges that you have 1 prior felony conviction for unauthorized possession of a controlled substance in Minnehaha County with a conviction date of June 29, 2009. If you were convicted of either or both of the felony charges in your indictment and of the Part 2 information, the impact of the Part 2 information would be to increase the maximum sentence that you could receive for the possession with intent to distribute charge from a maximum of 10 years up to a maximum of 15 years in prison and a $30,000 fine. And count 2, the mere possession charge, from a maximum of 5 years in prison up to 10 years in prison and a $20,000 fine. Do you think that you understand that Part 2 information and its possible impact in your case?
Yes, I do.
Then I will enter a not guilty plea on Ms. Olson's behalf to all charges and matters against her in this case. There is a co-defendant, so I believe that would require the cases to be assigned to Judge Barnett unless there's a reason for a different judge assignment. Okay. This will go to Christian Jensen for the state, Your Honor. Ms. Hofer, is this your client?
It is.
Do you wish to address bond?
Please.
1 second, please. Okay, I am ready. Thank you.
Thank you, Your Honor. Bond is currently set at 25,000 cash, and we would ask that you consider a PR bond. Facts of this case are that the Sioux Falls Police Department was investigating the co-defendant, Mr. Robinson. They encountered him. He was driving a stolen Dodge Ram here in Sioux Falls. While they were following the Dodge Ram, Ms. Olson was driving a Honda Pilot and picked up Mr. Robinson. Mr. Robinson was carrying a black multicolored backpack, and they stopped Ms. Olson's car shortly after that. Subsequent to that stop, a search was done. A lot of methamphetamine, approximately 959 grams, were found in the multicolored backpack that Mr. Robinson had brought into Ms. Olson's vehicle. They later searched both vehicles. The stolen Ram that Mr. Robinson had been in had more methamphetamine in it. And I believe there was some found on his person. Nothing was found on Ms. Olson. It's clear that the drugs in the backpack belong to or I would allege that they belong to Mr. Robinson because he's the one who carried the backpack in. Also, in terms of a record, Ms. Olson, I believe her last felony conviction was from 2009, so quite a while ago. Other than that, not much on her record. 2005, there was a federal conspiracy charge where she did do 3 years, but that was approximately 27 years ago. South Dakota resident, her entire life, has been in the Sioux Falls area for approximately 27 years. And so she does have ties to this community, family that live here. So because of the facts of the case and her lack of record, I would ask for a PR bond.
Thank you, Ms. Ofer. Ms. Davis, could I hear the state's arguments on bond, please?
Thank you, Your Honor. State's original request on bond in this case was $100,000 cash. So at minimum, bond should remain as set, if not be increased, Your Honor. These two individuals are known methamphetamine dealers, and that's why they were under the radar of law enforcement and being watched. They were found with 4 pounds of methamphetamine, and while the backpack may have come from the co-defendant, this defendant did admit that she knew there were drugs in the car, which shows she is part of this transportation of drugs from out of Nebraska into our state here. She does have a prior arrest for distribution, and then those other convictions. Your Honor, this illustrates she is a danger to the community as well as a potential flight risk. We would ask at minimum bond remain as set. Thank you.
Thank you, Ms. Avis. Is Ms. Olson currently on probation or parole?
No, Your Honor.
Thank you. When the court addresses bond, the primary considerations are the extent to which a person may present as a risk of danger to persons in the community and or a flight risk. When I consider those factors, I consider the information provided by the attorneys for the parties. I also note there is a public safety assessment scale of 2 of 6 for failure to appear, 3 of 6 for new criminal activity. Noting all of these matters, it does appear to me that given the gravity of the offenses involved here and the alleged facts which led to those charges, that there are dangers to the community and a flight risk, or at least dangers of the same. So the conditions of bond will be that Ms. Olson's bond will remain at $25,000 cash only, with the conditions of release to include good behavior, stay in contact with your attorney, make all court appearances, no contact with co-defendant, no weapons, no alcohol, no driving without valid license and insurance, no drugs without valid prescription, and comply with pretrial services. So those will be the conditions of bond, and I will wish you good luck in your case, ma'am. Thank you. You're excused.
Thank you. Then I also have Avery Goodface. Janelle, just a second, I'm going to get a scheduling order. Thank you.
Did you say you have Avery Goodface? Okay. This is file CRI 25-5409, State versus Goodface. Ms. Avis is here for the state and Ms. Hofer for the defense. Sir, are you in fact Avery Francis Goodface?
Yes. Yeah.
Now, Mr. Goodface, could you hear and understand when I explained your rights earlier?
Yes.
Did you have any questions about that explanation of rights?
No.
No, I'm sure Ms. Hofer has them for you, but there's an indictment and a Part 2 information in your case. When I looked at your indictment, it charges that on or about July 24, 2025, you engaged in conduct which led the state to charge you with count 1, unauthorized possession of a controlled substance listed on Schedule 2, namely methamphetamine. That's a Class 5 felony, and if you were convicted of that charge, the maximum sentence you could receive for that would be up to 5 years in prison and a $10,000 fine. Count 2 is a misdemeanor charge. Do you think you understand the nature of that felony charge and its maximum sentence, sir?
Yes.
Then there is a Part 2 information
Monica,
alleging
thank
that you
you.
have one prior conviction for
Thank you.
possession of a controlled substance in Minnehaha County with a conviction date of May 31, 2023. If you were convicted of your new possession charge and that Part 2 information, the impact of the Part 2 information would be to increase the maximum possible sentence you could receive on your current charge up to 10 years in prison and a $20,000 fine. Do you think you understand that Part 2 information and its possible impact in your case, sir?
Yes.
Thank you. Then I would enter a not guilty plea on his behalf to all charges and matters against him in this case. By file number, I would have his case to be assigned to Judge Barnett unless there's reason for a different judge.
Not that I'm aware of.
Lawton Luke for the state.
Ms. Hofer, is this your client?
It is.
Michael, I think it's just me and you. I'm pretty.
Mr. Goodface, I'm just finishing signing your scheduling order, and you get your own copy of this. When you read it, you might think it looks like legalese, and what I try to tell people is just make sure you stay in touch with your attorney throughout your case so she can defend you and you don't somehow end up with a warrant out for your arrest for losing contact with your attorney or a charge against you for not coming to court. But otherwise, I wish you good luck in your case. I think he has a prior personal recognizance bond, so you're
Yes.
excused, and I wish you good luck, sir.
Thank you.
Morning, Your Honor. Jason Coyson appearing with Lewis Running Bear.
Okay. His file number is CRI 25-5676. Ms. Avis is here for the state and Mr. Coyston for the defense. Sir, are you in fact Louis or Lewis Wilson Running Bear?
Yes, Your Honor.
Mr. Running Bear, could you hear and understand when I explained your rights?
Yes.
Did you have any questions about that explanation?
No.
And sir, when I look at your case, as I'm sure your attorney has shown you, there's an indictment and a Part 2 information. The indictment has one felony charge alleging that on or about August 1, 2025, you engaged in conduct which led the state to charge you with one count of second-degree escape. That is a Class 5 felony, which has a maximum sentence of up to 5 years in prison and a $10,000 fine. So first,
So if you just kick your cell door, look, I'm good now, Micah. I made it. If you just kick your cell door, that's escape. They get you for escape.
I'd ask you, sir, do you think you understand the nature of that
Love's
charge and its maximum
Little
possible
white dove
sentence?
with a love.
Then there's a
Biggest
Part 2
sky.
information alleging that you have one prior conviction for simple assault, attempt to cause bodily injury, a third assault offense conviction with a conviction date of December 16, 2024 in Minnehaha County. If you were convicted of the current escape charge and that Part 2 information. The impact of the Part 2 information would be to increase the maximum sentence you could receive, 10 years in prison and a $20,000 fine. So I'd ask, sir, do you think you understand the nature of that Part 2 information and its possible impact in your case?
Yes.
Then I will enter a not guilty plea on his behalf to all charges and matters against him. By file number, his case would be set with Judge Barnett unless there's a reason for a different judge.
A motion to revoke is with Judge Johnson, Your Honor.
Unfortunately, I think almost Judge Johnson might actually essentially be a witness due to one of the things that I think would be a defense in this matter. So I think it'd be best to not have the escape in front of Judge Johnson. And I'll kind of get into that in my request for bond.
So should we go back to Barnett? And then if that doesn't work out, to contact court administration if you need a.
I mean, I guess whichever, I have a feeling, who's this going to be set with as far as this state is concerned?
What does that matter?
Oh, well, I was just curious. I guess it only matters when it goes in front of which judge, but I think we should go in front of Barnett, to be quite frank.
Well, let's set this with Barnett right now, and if there becomes a need to change to a different judge, I would just ask the attorneys to contact court administration and get that ball rolling.
That makes
So,
sense.
1 second, because then at least we'll have the case moving forward with scheduling order in place
Yep.
and judge and attorneys assigned.
It will then be Lawton Luke, Your Honor.
Oh, I wish I could
Mr.
get these
Koisman,
judges.
is this your
Oh,
client?
It is, Your Honor.
You wish to address bond?
I do, Your Honor. I believe it was set at $2,500 cash at his initial appearance on August 4th.
Can you give me just a minute so I can start writing?
You
he
bet.
can't. He can't do that. It's not proper grammar. It's not proper English. He can't. He can't type it. He can't. His mom will kill him. I need you guys to pick a number. This is number 1. This guy is number 2. Do you need me to slow down? This guy is number 3. This guy is number 4. This guy is number 5. And this is number 6. Pick a number between 1 and 6. Here we go.
I'm ready now, anytime.
Thank you, Your Honor. Your Honor, this escape charge stems from when he was granted a furlough to go to the Glory House. When he was sentenced, well, essentially resentenced on a motion to revoke in front of Judge Johnson, Judge Johnson had indicated that he was sentencing him to serve the rest of his time, but that he would furlough him to the bed date at the Glory House once that day arrived. And he made it pretty clear on the record that he was just holding him until that bed date and then granting the furlough to make the jail transport him to ensure that he got at the Glory House. But then was pretty clear that once he was at the Glory House, he would amend his sentence to just credit for time served, which would in effect then do away with the furlough, and he would no longer be on conditions of furlough. Unfortunately, the order to that effect was not submitted and signed right away, so that order hadn't been signed yet at the time that he then was terminated from the Glory House, and then as a result picked up this escape charge. But right now,
Sir, there are children in this chat. Sir, Mr. Defense Attorney, you need to stop. That's the name of Donald's favorite watering hole. All right, we picked 3. This is 3. After this guy goes, then we go to Judge Ponder. Judge Eric.
he is on a no bond on that motion to revoke, as they did file a new one for being discharged from the Glory House. But considering the original intent of the court and what information would have been addressed to Mr. Running Bear in the courtroom by the court. I think the intention of the court is that he was not still be subject to an escape charge at that point, because the furlough should just not have still continued on at that point. So for those reasons, I am asking for a PR bond here in this matter. Although obviously, as I indicated, he still is on a no bond on the motion to revoke that will probably be heard later this month in front of Judge Johnson.
Thank you. Is he on probation then right now?
Yes, he's on probation.
Thank you. Ms. Avis, could I please hear the state's arguments?
We'd ask that bond remain as set, Your Honor. This defendant has a pretty extensive history. As noted, this is an
I'm at the Glory House.
escape charge here. Regardless of defense's argument, defendant didn't turn himself in, was instead located 2 days later drinking beer in a public park. He has shown he doesn't abide by court conditions. I would also note that his PSA score
With
is a
Goodface.
6.6. Thank you.
Kit Kat, eventually she will have to. Last week alone, I've added 2 more banned words to my YouTube chat because of Donald. 2.
When the court addresses bond, the primary considerations are the extent to which a person appears to present as a danger to persons in a community and risk of flight. When I consider all of these matters, there does seem to be a potential risk of flight, but considering the charge and the matters presented by counsel, including the public safety assessment score of 6 of 6 for failure to appear and 6 for 6 for new criminal activity, I still believe it would be appropriate to reduce Mr. Running Bear's bail to a personal recognizance with other conditions to include good behavior, stay in contact with your attorney, make all your court appearances, no weapons, no alcohol, comply with probation. And I'm sure probation is also no alcohol. No driving without valid license and insurance, no drugs without valid prescription, and you must
Now I'm picturing you in the bedroom, Ellen.
personally go to the probation office in Minnehaha County Courthouse and check in there with whoever you can find if your probation officer is not available when you go there, no later than 24 hours after you're released from jail. So you have to get reestablished contact with probation if you have not been in good contact with probation. And other than that, I'll wish you good luck in your case, sir.
Thank you, Your Honor.
Yep,
Thank you, Your Honor.
they have documents for you, so don't walk off just quite yet.
On this case, but you're still held on the motion to revoke. That'll be the next thing to address. Here's step over there. They'll have you sign.
Good morning, Your Honor. I've got Kurt Adams.
Good morning. Mr. Adams' file is CRI 25-5614, State versus Adams. Ms. Avis is here for the state and Mr. Braun is here for the defense. And sir, are you in fact Kurt Wayne Adams?
Yes.
Mr. Adams, could you hear and understand when I explained your rights earlier?
Yes.
Did you have any questions about that explanation of rights?
No.
Now, sir, when I look at your case, there's an indictment and a part 2 information. I'm sure Mr. Braun has those there for you.
Yes.
The indictment charges that on or about July 31, 2025, you engaged in conduct which led the state to charge you with 2 counts. In other words, counts 1 and 2, and both of those are for aggravated assault against a law enforcement officer. Each of those are class 2 felonies with maximum sentences then of up to 25 years in prison and $50,000 per charge. Do you think you understand the nature of those charges and their maximum sentences, sir?
Yes.
Now, the Part 2 information alleges that you have one prior conviction for aggravated assault with a deadly weapon in Minnehaha County with a conviction date of December 12, 2022. If you were convicted of either or both of the charges in your indictment and the Part 2 information, the impact of the Part 2 information would be to increase the maximum possible sentence you could receive for either or both of your current charges from 25 years in prison up to 50 years in prison and a $50,000 fine per charge.
Damn.
So, Mr. Adams, do you think
How do they pay $50,000 if they're in prison for 50 years?
you understand that Part 2 information and its possible impact in your case?
Yes.
Then I will enter a not guilty plea on his behalf to all charges and matters against him. By file number, his case would be set before Judge San unless there's a reason for a different judge.
Your Honor.
This will go to Randy Sample for the state.
Mr. Bunn, is this your client?
It is, Your Honor.
Thank you. Do you wish to address bond?
If we may, Your Honor, please.
Yes, one moment, please, then. I'll need to start that paperwork.
PR, PR, PR. That's what he's going to say. Those 3 words.
I am ready now, thank you.
Thank you, Your Honor. Mr. Adams has been in the Sioux Falls area for 5 years, but in South Dakota his entire life. Is seeking employment. He usually receives disability. It's my understanding that he's completed the paperwork on that. We typically do struggle with some mental health issues. While at the jail, he's been on medication for those. However, works with Southeastern Behavioral when released. He does have that parole hold and some previous crimes of violence, as the court indicated on that Part 2 from 2022, as well as a simple assault from 2018. Otherwise, history is kind of hit or miss there. In this situation, Mr. Adams was on parole. According to the reports, officers came because Mr. Adams was not taking his mental health medications. They wanted to check on him. They believed that he was intoxicated. He was kind of walking around, wasn't really listening or standing still in order to answer questions. One officer indicates that he reached into his pocket, Mr. Adams did, and pulled out a pocket knife. Never extended the knife, never made any threats towards them, just had the knife. The other officer, who had his taser out already, didn't see the knife, but when told by his partner that Mr. Adams had a knife just in his hand, he tased him. Mr. Adams was then placed in custody. PBT was a 209, a .209. But otherwise, it sounds like never actually made any threats. Could have easily just been emptying his pockets, and then was tased. He does have that parole hold as indicated, but otherwise, we'd ask the court to consider a PR bond here.
Oh, security missed another taser. Oh, that hurts right here.
Thank you, Mr. Braun. Ms. Avis, could I please hear from you for the state?
Thank you, Your Honor. We'd ask that bond remain as set. This defendant did pull out a knife and brandish it to his parole agents while being on parole for an aggravated assault with a deadly weapon already. These facts in and of themselves are incredibly dangerous and concerning. So the high cash bond that's already set is warranted, and we'd ask that it remain. Thank you.
When the court addresses bond, the primary considerations are the extent to which a person may present as a danger to others in the community and a risk of flight. I would note not only the information provided by each of the attorneys and the information derived from the charging documents in this case, I also note that Mr. Adams has public safety assessment scores of 3 out of 6 for failure to appear 4 out of 6 for new criminal activity. When I consider these factors in this case, it does appear to me that there are concerns for dangers to persons in the community and risk of flight due to the factual allegations described to the court and the charges and the potential penalties that could apply on any conviction for the charges. So the terms of release on bond would be payment of $10,000 cash bond, good behavior, stay in contact with your attorney and make all court appearances, no weapons, no alcohol, comply with parole, no driving without valid license and insurance, no drugs without valid prescription. And those will be the conditions of release on bond. Otherwise, I will wish you good luck in your case, sir. And you'll get your documents in just a minute.
Thank you, Your Honor.
Thank you.
Those are yours if you want. All right. So I state your name. And then I got some for you.
Nan, I thought of you yesterday. Nan, I thought of you because I thought, oh, I'm so glad Nan didn't see this. And I'm going to tell you about it anyway. Because it's been many, 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 many years since I've done this. And I'm sure for you too. And I don't know how, because I know how to use an oven. We all know how to use an oven in here. We use it every single day. I burnt myself in the oven. So I was pulling out my ribs. I was making ribs. And I hit the top rail and I thought, the first thing I thought, I swear, is, oh my God. Nan would laugh at me right now. So my hand is burning because I'm an idiot, right? And I have to go get my daughter from work. So I have a bunch of stuff in my hands. I don't have a purse. That is a mosquito. I don't have a purse right now because my cat's scratched my Harry Potter purse, so it's ruined. So I have my stuff in my hands. And I open the door. I'm running late. I go outside, and when I open the door to go outside, one of my cats that are not allowed outside went outside. So I throw my stuff on this cute little bench I have on my porch. I have this tiny little bench on my porch. And I get the cat. Well, that bench apparently grew a bee's nest. So my hand is burning. And I get stung on my legs while I'm carrying Keo back in the house. So I'm almost late to get my daughter. I'm in the house. My legs are on fire. So I'm like, Anthony, hurry up. Go get me something from the freezer. Go get me something from the freezer I can take with me to go get Tiffany. So he did all right. He did. My son knows me. It was a crime, but I didn't get caught, and I don't think that they would have cared. He got me my Jägermeister bottle. So I'm going down the road. I'm driving down the highway, trying to hold my Jägermeister bottle on my legs and on my the whole way there and back to freeze these bee stings. And it all started, I wouldn't have got stung by a bee if I wouldn't have burned my hand. If I wouldn't have just burnt my hand. How do you burn your hand in an oven when you've pulled stuff out of it? My pull-out game is weak. It appears with age, your pull-out game gets weaker and weaker. But that's why I thought of you yesterday, Dan. I thought, oh my God, if she saw I burnt myself in the oven, which is stupid. We don't do that. We know how to pull things out of the oven without touching the oven. We do that. That's what we do. But no KS. He has to cook whether he gets burnt or not.
I'll chat with you over here in a second. Judge, I'm appearing with John Von Thaden. And also, Judge, I believe there's a file that I am not appointed to, and I would ask that you appoint me from the bench.
Okay, so I have 3 cases for Mr. Von Baden on the docket this morning. The file numbers of these cases include...
Just so you know, those ribs, I got mine first because that's how I roll. I cook the food, I get the food. I don't wait for them. I don't wait for anybody anymore. When I cook a meal, I put it out, I get my plate, and then I yell, dinner, really loud. And then I go away. I don't care. If they eat, they eat. If they don't, they don't. I do not care. But I came back down to the ribs a little later, and I don't know how he did it. I don't understand how he did it. My brain, I should have taken a picture. My brain has not wrapped myself around it yet. But you know, I cut myself a few ribs. And then I cut myself a few ribs. I cut myself a few ribs. And then Anthony came and he cut himself the ribs. How do you do that? So the ribs go like this. Okay, and I cut myself some ribs. And they were so good. And then he came and he cut himself some ribs. And I don't know how he did it. I mean, you would think that would be really hard to cut along the ribs this way. But that's what he did. He said he couldn't go the other way because he kept hitting a bone. So he cut them all. He cut all the bones. He just cut right along the top. How do you do that? I don't. Donald, he's really strong. So I don't think the bones were that hard to cut through for him. I think he was just. We went to a protest the other day, and for 2 hours, he held his side like this for 2 hours. I'm like, honey, you don't have to hold your arms up for 2 hours. He's like, what? No, it's fine. Okay, here's how you do it. Here's how you do it. I don't have a smoker or anything. If I want ribs, I got to cook them in the oven. So, you know, you dry rub them down, and then you let that dry rub sit for a while in the refrigerator, you know, dry rub, and then wrap them. And then you unwrap them, and you wrap them in foil, and make sure the foil's real tight, so nothing escapes, because you want them to cook in that foil. And I cooked them for 2 hours and 45 minutes on 350. And then I took the foil off, and then I smothered those suckers in barbecue sauce. And then I cooked them for 30 more minutes. And then my son took a knife and cut right through. Hi, Dexter. Sorry, I know I'm supposed to play court videos here, but I really try my hardest, but I can't do that. I just can't.
CRI 25-292, CRI 25-824, and CRI 25-1302. If Mr. Connors and/or the Minnehaha Public Defender's Office has not already been appointed to represent Mr. Von Thaden in each of these 3 files, he should be so appointed from the bench. Is there any other case that you are referencing, Mr. Connors, or have I identified all of them?
I believe you identified all of them. Thank you, Judge.
Thank you. Then Ms. Avis is here for the state and Mr. Connors for the defense. Sir, are you in fact John Robert Von Thaden?
Yes.
Sir, could you hear and understand when I explained your rights earlier?
Yes.
Did you have any questions about that explanation of rights?
No.
Now, sir, we'll take your cases one at a time, starting with the one arising from the earliest alleged conduct. That is file CRI 25-292. In that case, the indictment charges only misdemeanor events, but it charges that on or about December 28, 2024, that you engage in conduct that led the state to charge you with 2 counts of driving while intoxicated. That's counts 1 and 2. The other charges are class 2 misdemeanors. If you were convicted of either of those DWI charges as a DWI first offense, it's a class 1 misdemeanor with up to a year in county jail, $2,000 fine, driver's license revoked for 30 days, pay a DUI fee of $50. Do you think you understand the nature of those charges and their maximum possible sentences so far, sir?
Yes.
Now, the Part 2 information in that case alleges that if you were convicted of DWI in this case and of the Part 2 information, it would be a DWI third offense. That would make it a felony conviction, class 6, punishable with a maximum sentence of up to 2 years in prison, $4,000 fine, driver's license revoked for a year, same DUI fee of $50. The Part 2 alleges that you have a conviction for driving while intoxicated first offense in Lincoln County with a conviction date of August 20, 2018, and another conviction for driving while intoxicated first offense in Lincoln County with a conviction date of October 26, 2016. Do you think you understand that Part 2 information and its possible impact in this case, sir?
Yes.
Then I will enter a not guilty plea on your behalf to all charges and matters in this case. The next case, at least by date chronologically of the charges, would be 25-824. In that case, the charging documents include, again, an indictment and a Part 2 information. The indictment alleges that on or about January 21, 2025, you engaged in conduct which led the state to charge you with count 1, driving while intoxicated. As a driving while intoxicated first offense, it would have, again, the class 1 misdemeanor maximum penalties of up to a year in county jail, $2,000 fine, 30-day driver's license revocation, and DUI fee of $50. The other charges in the indictment are class 1 and class 2 misdemeanors. If you were convicted of, do you understand that charge and its maximum sentence, sir?
Yes.
Now, the Part 2 information in that case is exactly the same as the one I just described in the prior case. Do you want me to repeat it, or are you comfortable understanding that it's the same Part 2 information?
I understand it.
So it has the exact same effect, making the DWI case a potential class 6 felony with a maximum sentence of up to 2 years in county jail, $4,000 fine, driver's license revoked for a year, and DUI fee. Do you think you understand the Part 2 information in that case and its maximum possible sentence?
Yes.
Then I would enter a not guilty plea to all charges and matters against him in that case. Finally, in CRI 25-1302, the charges arise from allegations or alleged conduct on or about February 23 of 2025. In that event, the state charged you that you engaged in conduct which led it to charge you with count 1, simple assault in a domestic setting by attempting to cause bodily injury. By itself, it's a class 1 misdemeanor with a maximum sentence of up to a year in county jail, $2,000 fine. The other charge is also a class 1 misdemeanor, and that is for stalking, causing a credible threat, also in a domestic setting, same maximum sentence. Do you understand the maximum the charges in the indictment and their maximum possible sentences, sir?
Yes.
The Part 2 information in that case alleges that if you were convicted of the assault charge, which is count 1, it would be your 5th assault offense conviction, which would convert it
Monica,
then from a class 1 misdemeanor to a class 4 felony. The maximum sentence if you could receive if convicted of a class 4 felony is up to 10 years in prison and a $20,000 fine. That's because the Part 2 information alleges the following prior assault convictions: simple assault against a law enforcement officer with a conviction date of April 12, 2021 in Lincoln County. Aggravated assault against a law enforcement officer with a conviction date of August 20, 2018 in Lincoln County. Simple assault domestic with a conviction date of July 6, 2017 in Lincoln County. And simple assault against a law enforcement officer with a conviction date of November 27, 2018 in Lincoln County. Do you think you understand, sir, that Part 2 information and its possible impact in your case?
Yes.
Then I will enter a not guilty plea on his behalf to all charges and matters against him in that case as well. By file number, I would have these cases set before Judge Sabers unless there's a reason for a different judge.
Your Honor, the DUI files are going to go to Tarek Maluf for the state. And then 1302 will go to James Sadkovich.
Arrested and I got arrested on Sunday. I found it out. No, I was here. I didn't get arrested March to April 10th. Because the March charges is the one that fucking had another shit off the text message. Yeah, the marijuana was charged by this. March 1st. Text messages.
That was the dog. The dog did that. But we're okay now. But we are not, in fact, okay right now, are we? It's all right. I'll fix it. I'll fix it. I'll fix it. Oops. Remove. Stop sharing. There we go. The dog yanked my cord. But she can do anything she wants, so she's fine.
I do want to ask the court to consider reinstating the 1,000 cash bond out of he paid on 25-1302. Otherwise, we would like to reserve for the other two files, Your Honor.
In that case, that's what I'd call the assault case. When I looked at his bond history, he had a PR bond, failed to appear at arraignment, and put a cash-only bond of $2,500 in place, March 19, 2025. So I'm not sure if there was on a prior bond of $1,000.
So I believe he paid, from what I'm seeing, he paid on February 25th. I believe that was the day after he was arrested.
I do see that, a bond receipt for $1,000 cash on 2/25. So what are you seeking on that now then?
Judge was asking that you reinstate the 1,000 on that file, and we would reserve on the other two files.
I see. That $1,000 came about before the PR event that I was describing and the $2,500 cash bond. What's the state position on that?
Your Honor, we'd ask that the $2,500 bench warrant be converted to the bond in that matter. This defendant has an extensive violent history dating back to 2012. So if we're just talking about the simple assault file here, the court can still take into consideration the fact that he's got two other felony files in front of the court today that he failed to appear on. Then with this file, if we start back at 2012, he has a domestic simple assault charge. June of 2013, simple assault domestic, later dismissed. December of 2013, simple assault conviction, domestic. November of 2014, simple assault on law enforcement that he pled to. 2016, DUI conviction. 2017, simple assault domestic conviction. December 2017, DUI resisting and a simple assault on Leo. December of 2020, simple assault domestic and a threatening law enforcement where he was convicted of the simple assault domestic. December of 2024, he has that pending DUI third. And then the January 2025, the pending DUI third. He actually has history, Your Honor, that goes back to the late 90s from out of state. Here, he assaulted his ex-girlfriend for about 2 hours. She wanted to leave the situation so he could sober up. And he ended up holding her face in the couch, telling her that he would tie her down in the bedroom and kill her over the course of the next 3 days. So, Your Honor, if anything, the $2,500 cash bond is low and should maybe be considered to be increased. This shows he is a very high danger to the community, specifically to this individual. And he's also a flight risk, which, as shown by his failures to appear in these 3 felony files.
I'm going straight to hell when I die because you know what makes me the saddest about that is the dogs didn't get fed. They didn't feed the dogs. That's what I'm sad about. That's the part that got me.
Is Mr. Von Thaden currently on probation or parole?
He was just put on probation out of Minnesota, I believe, last week.
When the court addresses bond, the primary considerations are the extent to which a person seems to present as a risk of danger to persons in the community and a risk of flight. When I consider these matters in this case, which is only going to be considered as a consideration of bond in 25-1302, the court considers the information provided by counsel. The court considers the public safety assessment scoring of 5 of 6 for failure to pair, 6 of 6 for new criminal activity. Based on this information, it does seem to me that bond was appropriately set at $2,500 cash only, and I will leave it set as such. So if he wants to be allowed out on bond, I won't just reinstate that bond. It will be $2,500 cash only, in addition to the $1,000 cash bond already in place. Posted on (2/25/25). And the conditions of release on bond will continue to include or will include good behavior, stay in contact with your attorney and make all court appearances. No contact with alleged victim Nicole McKenzie. No weapons, no alcohol, comply with probation in Minnesota. No driving without valid license and insurance, no drugs without valid prescription, and comply with the 24/7 project by whatever is available of scram bracelet or remote breath or otherwise PBTs twice daily. Thank you. We'll be in recess. Good luck in your case, sir.
Okay, we didn't make it to number 3. We just didn't. But if I don't switch, I won't get to play any of Judge Ponder at all. And I do love him so. I think it's this one, but I don't know. I might pick.
I'd ask, do you think you understand that part
course,
two information? And it's
He will do less time.
If I have a 50-50 chance of something, then that's when you double down on whatever I am not picking. That's when you pull out your wallet and put your house on the market and you take all of that money and you put it on whatever I am not picking. So I just uploaded, I know I'm going to confuse everyone. I already know this. I know I spoke about Twitch lately and that was difficult. And Discord is always difficult. And you guys just want to watch YouTube videos. I am not asking any of you to go watch this. All I'm saying is, since we ran out of time, you're not going to be able to see a lot of Judge Eric. Although probably I'm going to play some of this tomorrow because it's a real good docket. But guys, I am not asking you to go do this. You do not have to go and do this. Please. Okay? If you wanted to see the whole docket, well, not the whole docket. I clip it in parts. If you wanted to see this whole part of this docket, which is 3 hours long, I have put it on Patreon. That is how you get to it. I have lots of other videos there. I have Leghorn. I have Judge Reeves. I have Judge Fleischer. I have the Australian court. I have hours and hours and hours and hours of an Australian trial. I don't have the verdict, though. You're going to have to look that up. But if you want to see this docket, because I don't have time to show it all, even though I will show some tomorrow, you are welcome to go to Patreon. It is free. Okay? You can get a paid membership. But just to go and watch the stuff that I post is absolutely free. And it's the only way I know to put stuff somewhere where you guys can see it. If I would try to upload that into YouTube, they would nail me because I'm not talking during it. It's just this docket. It's not me at all. I'm not in it at all. So, no idea, Kelly. So, there's the link to Patreon. You are welcome to go and watch any of my videos there. They're all free. And I don't think I'm in any of them. So, if I talk too much for you, you can go there and you can for free. You don't have to do anything. And I'm not asking you to do this. I don't need views. I don't need you to go over there. That is all for you. If you wanted to go there, you can. All right. Back to Judge Ponder.
He will do less time than the time announced in court. I understand that, but nevertheless, this is still a substantial amount of time. He's going to be trying to work on programming in the Department of Corrections to address the addiction as best as he can. But he understands this is a punitive measure. This is a very punitive sentence, and he is pleading to essentially the top count in both.
I just uploaded it, just like right now while we were talking. Tina P has already liked that video over there. Tina, I love you. You know that, right? I love you.
These cases and taking responsibility for his actions here. So in light of that, we would ask the court consider running some amount of this sentence concurrent to his other sentences. Is this right?
Sir, you have the right to tell me anything you'd like me to know before I sentence.
If you want to, just speak into the mic.
I want to start off by, apologizing to not only my victims, but to the community and the courts, my family. Yes, I know I have been struggling with my drug addiction for many years, but I can't put the blame on everything on that. I made the choices that I made. I gotta let them consequences. Thank you.
And sorry, Your Honor, I thought the court was asking about plea disposition. I do have some comments on sentencing.
All right, starting with.
With regard to the case ending 6887, I just wanted to note there is a restitution request of $3,912.80. I would ask the court to order that. In the case ending in 1911, we did receive some information on restitution, but I don't believe it's sufficient to make a request. I would ask to reserve in that case. With regard to the consecutive versus concurrent piece, the victim in that case indicated, and I think this mirrors some of the comments the court has made in motor vehicle cases previously, that the theft had been exceptionally hard for her. She was homeless in the past. This event triggered her PTSD from past events, grieving the things she lost, does not want the defendant to do this to anyone else, and wants him to be incarcerated so he can't do this to anyone else.
Sir, you just created a hoarder. In 5 years, this lady's going to be living in mess because she can't give anything away because she's scared people are going to steal all of her stuff. You created a hoarder. It's going to cost her $10,000 to get that cleaned up. Want to know how I know that? Midwest something. There's this channel on YouTube I've been watching the last 2 days. Just Midwest something cleaner. I don't know. It's just this guy who cleans houses, and I saw him do some hoarder houses, and he's like, for her to get someone in here to help her, it costs $10,000. I was like, what? Wait a second. Hold on. Time out. Hoarders pay $10,000 to get their houses cleared out. Is that what I heard? Yeah, that's what I heard. But you can do that in like 6 days with like your kids. 10,000. Guys, we are in the wrong business. We have to find some hoarders with $10,000. You can use my kids. You can use my kids. They're not very helpful, but they're there. We need to start clearing out hoarder houses. 5 years, sir. I'm going to make $10,000 because of you. I'm going to go clear out that poor woman's house. I know. The ones that he does though are, they're bad because the hoarders have passed and then they left this huge mess for the kids. And the kids are like, I don't care about anything. I just clean it so I can try to sell this piece of crap house. So they do have some good stuff though. They do. They have like 80, give me a name of a bag. Nothing is coming to mind. Gucci bags in this hoard, and they can't afford to get their sink fixed. You know what I mean? I don't know how to find people that'll pay that much. I wonder how many hoarders, hi Sherry, we have in Pennsylvania that need their hoard cleared out for $10,000. I just can't imagine anybody having $10,000 if they're a hoarder because they spend all their money as soon as they get it on stuff. All right, maybe we should not do this job. Maybe this is a bad idea to get into clearing hoarders' houses, guys. Don't use my kids. I think it's a bad idea because actually I don't want them to bring bugs home. I have some moths and some mosquitoes, and they're enough for me. Because every time I see a moth in my house, I feel like all of my clothes are gonna have holes in them. I can't help it. I see a moth, and I'm like, oh no! But okay, if you guys do find any hoarders that need their house cleared for $10,000, please call me. Call me right away. I'll fly. I'll fly somewhere to do it. $10,000? Yes, sir. Yes, $10,000. I'll clear out a hoarder's house. No problem.
In the grand scheme of the cases that are handled through this court, motor vehicle is not the most serious in terms of bodily integrity, but as the court has noted, in other cases, it can seriously set back a person's life. Mr. Sandoval has a long history of these types of cases, and so while the 35 to 50% of the sentence that he would be serving is a significant amount of time, it's also, I think, justly warranted based upon that history. So given that pretty extreme departure in how the Department of Corrections and the legislature has set sentences to be run, the people's recommendation would be consecutive sentencing as to his out-of-county matters.
All right, well, I didn't think you had anything to say. I usually give you the last chance. Anything to add?
No, Your Honor.
Well, it is unfortunate we've gotten to this point, but Mr. Aziz is absolutely right. There are a lot of people in our society that are one paycheck away from being homeless. And you take their car and they can't get to work, or it's their kids who can't go to school, or they're can't go to dance recitals or soccer, all because you're feeding the market for stolen cars, if not stealing them yourself. And we're looking at 3 other cases, all motor vehicle thefts. You're exactly right. You can't blame everything on the drug addiction. You're choosing to victimize other people. And your attorney's arguments are well taken. At some point, enough is enough time-wise. But buddy, you're already getting a massive break having 23 years worth of sentences all run concurrent. And I just can't do it again. There's going to be, people have got to understand you are going to do time, and there's no volume discount. You're already going to get a volume discount, but it's not going to be even greater. I'll go along with the stipulation in this case. Which is against my normal practice. Normally, we'd be looking at much more than 8 years if it were up to me, given the max and that you were on parole. But I will go along with the disposition in this case to 8 years in the Department of Corrections in each case, consecutive to each other, and consecutive to the Jefferson County 24 CR 2840, consecutive to Adams 19 CR 5050, and consecutive to Adams 21 CR 225. I'll note the 152 days of pre-sentence confinement credit in 1911. In 1911, we'll reserve restitution. That'll be determined within 63 days. I ask the prosecution to please make concerted efforts to talk to the defense, ascertain their position, consult with them. If there's an objection, any objection, note it in the motion, and written objection is due within 2 weeks, and then we'll get that motion set for restitution within the 63 days the statute provides us. In 6887, we'll note the $3,912.80 in restitution. Do we have that? Apparently we need a worksheet in that case. Is there any objection to that amount from the defense? Well, I think there was a stipulation to liability, but yeah, I guess not to the amount. Are we agreeing to that amount in that case?
Your Honor, it is my understanding that another individual was charged and pled to motor vehicle theft of that same motor vehicle as sort of who had at first situation here. And I don't know if restitution was ordered in that other defendant's case. If I can just have 2 weeks to note whether there's any objection to that amount and
whether it needs to be joint and several.
Or if it needs to be joint and several.
All right, well, let's get the worksheet filed, and we'll have 2 weeks to file a response. In that case, we'll note the 279 days of pre-sentence confinement credit in 6887. There is a 3-year period of parole in each of these cases. To the extent there's any overlap in parole between this case and other cases, that can be concurrent. Anything else from the prosecution?
The restitution worksheet's been filed just now.
Nothing further from the defense. Thank you.
All right, that'll conclude these matters. Mr. Vigil Martinez has kind of been here all morning. If your guy's ready, or if your client's ready, let's do it, and then we'll take our break since we're already late.
Needs to complete paperwork and then we'll be ready.
Oh, all right. Well, we're going to take a 25, 30-minute break. We'll see everyone in a few minutes.
I'm always 25, 30 minutes late, Judge. It's fine. You know, it doesn't mean you're a bad person. It doesn't mean you're not trying really, really hard. It just means that you're 20 to 30 minutes late. And that's what it means. It looks like he's pondering. It looks like I'm going back too far, but they're really talking. Oh, he's talking. He's talking. He's talking. Okay. He just jumps right in talking today.
And how far have you gotten in school?
I have a bachelor's degree and some other work as well.
I asked that question of everybody because obviously the paperwork that you signed is in English. This hearing is being conducted in English. So I like to make sure that people read, speak, and understand English, and I presume you do.
I do, sir.
Are you a veteran of the United States military?
I am not.
Under the influence of any drugs, alcohol, medications, anything that would be affecting your judgment today?
Not whatsoever, sir.
Satisfied with the representation you received from your counsel?
I am.
Counsel, you have a constitutional obligation to ascertain your client's nationality, and if he's anything other than a U.S. citizen, you have an affirmative obligation to inform him of the immigration consequences that this plea would have on his specific immigration status. Are you in compliance with your obligations?
I am, Your Honor.
The count to which you are pleading guilty, sir, reads that between November 1, 2024 and April 1st, 2025, you, with the intent to harass, annoy, or alarm Lindsay Goodwin, did unlawfully follow a person in or about a public place. To that count, do you plead guilty or not guilty?
Guilty, sir.
Okay. Before I accept that plea, let's make sure that you understand. Well, first, let me confirm that you are admitting that you were or are in a intimate relationship with Lindsay Goodwin, such that this is a crime of domestic violence.
Yes, sir.
And you understand that a class 1 misdemeanor in Colorado carries a potential sentence to the county jail of up to 364 days?
Yes, sir.
So you have the paperwork there in front of him?
I have it up on my computer. I can show.
That is fine. The request to plead guilty, Rule 11 advisement that I guess you're looking at there and you signed has been up.
My dog decided to do it again, and I'm not yelling at my dog because my dog is perfect. Perfect. My dog is the best dog ever, 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 ever. There we go. Quick girl.
Uploaded with the court so that you and I are looking at the same document. The initials that are next to each numbered paragraph, did you put those there?
I did, sir.
Does that mean you went through this document line by line with your attorney?
Yes, sir.
And if you had any questions, did she answer them?
She did.
Any questions for me about anything that's in that document?
I do not, sir.
Main thing I want to call your attention to there on page 1, you'll see a paragraph 2. It's got lettered paragraphs A through H. These are all the rights that you have. Your right to be presumed innocent, have a trial, appeal, etc. As outlined in that document right there, do you understand that you have each and every one of those rights?
Yes, sir.
Do you understand if I accept your guilty plea, you're giving up all of those rights?
Yes, sir.
All right, finally, sir, I do not accept pleas of guilty from people who tell me they've done nothing wrong. That's what trials are for. So now I ask the DA to tell me what facts he would prove at trial that support this charge, or a greater if this is a fiction. And when he's done, I'm going to ask you if that's what happened. Counsel.
Your Honor, between January 2024 and March of 2025, the defendant sent multiple unwanted messages to the victim, would continually pass by her apartment, and showed up to her business on 2 separate occasions.
Now what happened, sir?
Yes, sir.
Understanding the rights you're giving up, understanding the potential penalties, do you still want to do this today?
I do, sir.
I will accept your plea, find that you've entered into it knowingly, intelligently, and voluntarily. What are we doing about sentencing?
And we are asking to set over. I understand the victim does wish to be heard at sentencing, so we are requesting a PSI.
Do we need a PSI on the misdemeanor? With no history? I can set it over so for the victim to address the court, but
I shouldn't have pinned those two together. Both the victim wants to be present in court and Mr. DeCecco is asking for a PSI, given that jail is on the table and a mental health eval is requested. I don't know exactly what that note means, but Mr. DeCecco is requesting a PSI.
it was October 13th for sentencing.
That's fine with people.
That's fine. That works for us, Judge.
Looks like he posted a cash bond. So we'll allow him to stay out pending sentencing. Your attorney will explain to you what's going to happen if I order the PSI, which I am. I don't know if the mental health evaluation and treatment happens now. I think it's probably condition of probation is my guess, but we'll note that.
Yes, Judge, I don't think we'd be able to get a mental health evaluation done
Yeah.
prior to sentencing. And again, he hasn't been sentenced yet. So I imagine from my conversations with Mr. DeCecco, as well as what's in the plea paperwork, that will be a condition of probation, as will obviously domestic violence evaluation and treatment.
All right, so your attorney will tell you where you need to go, and you will be back here on October 13th. You want 8:30 or 1:30?
Either one works. 1:30? 1:30 would be best for us, Judge.
1:30 in the afternoon. We'll see you then.
And Judge, I just have one additional request, which is at this time, we would renew the request to remove the ankle monitor, given that at this point, Mr. Eggerman has pled in this case. He will be sentenced in October. And so it has now been even more time that he has been on this ankle monitor over, I believe, 4 months at this point that he has been
From April 1st.
in compliance with this ankle monitor.
Prosecution on notice that this was going to be brought up today, and are you in the RA compliance?
I was just checking the notes, Your Honor. I see that we did address the GPS on July 14th. And
Just presume that Mr. DeCecco may have checked again with the victim when he was VRAing the offer.
well, I don't know about, let me just double check that. She's worried about the MPO staying in place. From everything I can tell, to the extent that we have discussed any conditions of bond, she's made it very clear that she has concerns about her safety. And I don't see that we've ever explicitly, or at least since the last court, haven't explicitly raised the issue of the GPS.
Judge, I might have mentioned it in an email, but we've also been in plea negotiations, so I don't know if Mr. DeCecco had just missed that request.
Would you go ahead and put in writing?
Yes, Judge.
DA, why don't you just, you know what's coming. Within the next week or so, you can respond. I'll rule on paper. The reality is he's not going to be on an ankle monitor through probation. That's not going to happen. The MPO will stay in place. Obviously, we know all that until he's done with any sentence. But having pleaded guilty at this point and to a misdemeanor, it's a change in circumstances. So I'll address, I'm willing to address it, but it's part of the Constitution that the victim has a right to know. And so, pardon me. So your attorney will get that in filed. The DA within the next week or so will give their position after consulting with the victim, and then I will rule on paper. And if I grant that, then your attorney will tell you and you can go to pretrial and get that taken off. We'll do it that way. All right, anything else from the prosecution?
No.
Defense?
Judge, is there instructions on setting up that PSI?
Pardon me?
Are there instructions that he'll receive on setting up the PSI, or should he go over today to do that?
You can go over to, probably the easiest thing is just go over to 303 West Colfax and just get that started. It's on a different floor than where you have been going. But they when you get there, they'll tell you which floor to go to.
I'm sorry, I just don't know what a PSI is.
Pre-sentence investigation report.
Oh, okay.
Yeah,
I'm
yeah.
sorry, I forgot that.
That's all right.
Yeah, sorry.
We have a lot of that.
All right, so just head over to 303 West Colfax. They'll get you to the right floor, telling you need to get the process started for the PSI.
Okay, thank you.
Have a good
Thank
day.
you, Judge.
You too. Thank you.
Your Honor, this is Mr. Claybrooks, number, sorry, I'm not seeing it on the court's docket.
I looked at it. Should be there somewhere. What's that? 72.
Got it, thank you.
All right, 24 CR 4320. People versus Claybrooks. Entry.
Daniel Cohen, on behalf of people.
Anthony V. Hill Martinez with the Public Defender's Office on behalf of Mr. Claybrooks, who appears in custody to my right.
All right, we've got a pretrial conference today. Pardon me, trial set for September 2nd. Prosecution ready for trial?
Yes.
Defense ready for trial?
Yes.
I am ready for trial, Judge. I am ready. Let's go.
Guerrero's the one we just reset, right?
Yes.
Oh, no, we withdrew the plea at the arraignment stage. All right,
It's
but that
not
one,
going to trial
it's
that
not
day.
going.
Yes.
McCumber's dismissed.
Guys. 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 Who else wants to see Bill and Judge Eric have a conversation? Bill, please drive to Colorado. Please, Bill. We all want it so badly. Drive to Colorado and wear a mic and just have a conversation. Oh gosh, please go out for coffee. Please. First off, I would die to hear what you two would talk about. I would give up one of my kids to hear that. Second off, I would die to hear the conversation move forward. Bill, please. It's all we want in life. Guys, beg him for me. Beg him. Use peer pressure. Use guilt. I don't care. This is why we call him Judge Ponder. I had to point that out because you guys didn't know. All right, I'm going to fast forward it. Here we go. 30 seconds. 1 minute.
All right, see everybody for September 2nd. It's possible I'll have coverage. I'll let you know as soon as possible.
And Your Honor, I would just like to make the brief record just to make sure everything is complete that by going to trial, Mr. Claybrooks has rejected an offer that was extended to him of an added count 3 of second-degree assault strangulation that would have been a sentence of sentencing range of 5 to 16 years in the Department of Corrections. He is, by the people's understanding, aggravated due to being on felony probation. So that offer has been explicitly rejected, and we will proceed on the first-degree burglary.
All right, see everyone in the second.
And Your Honor, I know that we probably set this at our disposition date, but I wanted to confirm, how large is our veneer?
This one's not DV, so I think it was a standard veneer. I think. There was no gun and no DV, so I don't think we went beyond standard.
Yeah, you had noted standard veneer on March 10th.
Great, thank you.
All right, see everyone then.
We can next call Mr. Denke. He's number 62.
He's number 62 because this judge's dockets are freaking long.
24 CR 6397, People versus Denke entries.
Daniel Cohen, on behalf of the people, for Bilal Aziz.
And Robert Sweska on behalf of Mr. Denke, who is appearing in person on bond. We do have an offer that Mr. Denke does intend to accept. That is a plea to a level 1 drug misdemeanor with a stipulation to probation. The issue that Mr. Denke presents with is that he just very recently lost his housing, and he's trying to work to get new housing under his belt before entering into these obligations with probation, and things are just kind of in flux right now, which is why we do not want to take the plea today. I would hope that we'd be able to enter this plea on September 8th if we continue the arraignment to that date.
No.
Afternoon, sir. All right, 1:30, please.
1:30 in the afternoon. Pardon me, goodness. And if we don't have the paperwork done then because we're coming up on a year old, so we really need to get this done. So don't waste your time, get done what you need to get done. Glad to hear that positive things are in the works for you. I'll see you back on the 8th at 1:30.
Thank you. And please just reach out to me once you get your phone.
Baskerville. This is Mr. Baskerville, number 2 and 3 on the docket.
Are there any dogs involved in this one? Yep, he has 100 people in his docket at most times. His docket is full. And he takes his time with them. How does he do it? I have no idea. Other people with 100, like Judge Manning and Judge Fleischer, they're like fast. They're like, phew, phew, phew. See, Donald, does he have a hound?
18 CR 2627.
No. Where's the hound? I want the hound. How dare you all?
19 CR 5074, People versus Isaac Baskerville. Afternoon, sir. Entries?
Daniel Cohen on behalf of the people.
And Jake Black on behalf of Mr. Baskerville, who's in custody to my right.
All right, so we've got a couple resentencings. How are we proceeding?
Your Honor, Mr. Baskerville would request a continuance of these resentencings. I requested some records from ComCore. I have not gotten them yet, and I think that they will be necessary and would end up in a 35B motion anyway. So I would be requesting that. And then also, he's got misdemeanor cases that are set next week. So I'm not sure if those are going to resolve, but I think that it makes sense to take this out a little bit if he's going to go to DOC rather than being written back. This is not a normal change of address. It was a 14-year sentence. So I do think I need a little time to be more effective and to get those records.
Well, I mean, it is a normal change of address in that, unless you think there's reason for him to be resentenced to probation, then we are going to be simply changing address. I'll give you some time because of the misdemeanors and let him get that taken care of, so that stuff's not hanging over his head, but we're not going to be wasting too much time on misdemeanors. How much time do you want?
I would ask for 30 days.
September 22nd?
That works.
All right, must be prepared to proceed on that date.
Thank you.
8:30 in the morning.
And Your Honor, I just wanted to briefly ask if the court knows priority for trials next week. I just wanted to figure out if I have a Monday start that I need to find coverage for that docket.
Actually, what you need to be paying attention to is the labor issues in Canada.
I did see that Canada put down that strike.
The judge who is covering is supposed to be flying in on Monday for a Tuesday start for your trial. So it looks like you're going to be in front of Judge Meyer, assuming his airplane takes off and makes it here.
Okay. And that would be in 5H then?
Yes, 5H with a Tuesday start.
All right. Thank you.
Sanchez alluding.
This is number Number 46, Mr. Sarno Sanchez.
I'm sorry, who's this? Oh, sorry. Okay.
46, okay.
That's Scheidemann. Check it out. Oh, okay. I do that correct. Oh. But I know it. Yeah.
25 CR 1402 people versus Sarno Sanchez. Entries?
Daniel Cohen on behalf of the people.
Jake Black on behalf of Mr. Sarno Sanchez, who's present in custody on a writ from DOC.
All right, we're set for an arraignment today. How are we proceeding?
Your Honor, we do have an agreement here. However, we kind of came to agreement today in court and Mr. Cohen needs time to prepare that paperwork. We would ask to set this over for a final arraignment.
Thank you, Monica. Thank you. Thank you.
Have a disposition at that time.
Kelly.
But Mr. Sarno Sanchez is asking.
Kelly, I'm glad you're feeling better. Gosh, breathing is important. It's so scary.
For a little bit longer because last time we did a continuance, it was just a few weeks and he was just held here. But he has a visit scheduled at DOC this weekend and he was hoping to make it to that visit. So I don't know how long of a continuance that needs to be, but I think maybe 3 or 4 weeks.
No, September 22nd.
That works.
Fine with the people.
Where are your visitors coming from?
They're coming from Denver, North Denver. So it's about
So they could visit
3 hours
here
drive.
today.
Yeah, but it's a contact visit and they took.
Oh, no contact visits here?
Time off work and things like that.
I hear you.
I appreciate it.
Kelly,
All right,
thank you. Thank you
8:30
so
on
much.
September
Thank you.
22nd. Get the plea paperwork loaded up. Sheriff will writ DOC for the 22nd. You have the right to be here in person. If it's a type of plea that you and your attorney agree that we can do plea and sentencing remotely, do you want to be remote from DOC or do you want to be here in person?
I'd like to attend in person.
All right, in-person writ on 9/22, but I think given that amount of time, they will not hold you here. So you should be able to make your visit. See you on the 22nd.
Okay, thank you. Have a good day.
No, that was just a deep breath. I thought you were actually stepping forward.
Gonna see if there's somebody.
All right, guys. 2 hours. We did 2 hours, guys, of our time today. Maiko, you got me through Goodface, and you don't even know you were doing something else, but at least you got me. All right, guys. Congratulations to, actually, it's Monica and Josh became mods today. And Martha, I want to make you a mod. I did DM you. I'm just, you are the mods of the comment. You would be the mods of the comments because you are always commenting on every single video. Martha has something like 1,200 comments on my videos. She's awesome. She's so amazing. So as soon as she says yes, I'm going to make her a mod too. All right, guys. Thank you so much for coming out. You're going to be popped right over to OJ in a second. Bill, you never answered me. I spoke to you and you didn't answer me, and it's all we want. I'll see you all again real soon. Wait till you see what I have for tomorrow. I have Florida. Bye, guys. Thank you.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps. She's the friend that she lights the way. Her eyes mirror sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm, in a wake there's no alarm. Streaming tales late into the night, her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm, in a way there's no